Thank you. Could you please address the Supreme Court use of shadow docket? And is that a final decision? And then does the federal court trump the state? And does the state need to change its opinions? Go ahead and answer that. Oh, yeah.
So shadow docket has been used excessively more and more often in the last couple of terms by the Supreme Court. It's a way that they deal with emergency orders where the state characterizes that they need an answer immediately in order to have the court issue it without full briefing and without full argument in front of the court. So they are binding opinions, and now they're treating those opinions as they're usually not very well reasoned. They're not very long decisions, but they are. The Supreme Court is now telling us that they are binding on us and that we're supposed to look at any reasoning that's included in the shadow docket decisions and treat them as precedent. So it's a little bit tricky. And yes, there's a supremacy clause in the federal Constitution that says that the federal Constitution and the federal Supreme Court is the ultimate arbiter of all federal law, and there are different provisions that apply to when the federal government has spoken on an issue. Sometimes they are able to preempt the field so the state can't make a different law on the same issue. So sometimes we do analysis of whether the state law is preempted by the federal law. And we have to spend quite a bit of time trying to figure out that the state legislature, this is a case I had not too long ago, and I'm not going to tell you what the answer is because it's going to the Supreme Court next, but it was an issue where the state legislature tried to keep nursing homes and rehab care facilities from contracting with forcing people who were in the nursing home to agree to arbitration. And there's a federal arbitration act that says that you can't do anything to try and make arbitration less favored than a jury trial or things like that. So the question was whether the state law prohibiting nursing homes from requiring people to agree to binding arbitration was preempted by the Arbitration Act, and we had to try and figure out whether the supremacy clause made it so that we had to invalidate the state law. So that's an active question before the Supreme Court right now. And oh. So do we need to change our decisions sometimes? We try and avoid that. We try and give voice to what it is that our legislature was trying to do. Legislative intent is very important to, that's the goal of our statutory construction exercise. And so to the extent that they found that there was a good reason to do that, we try and save the provisions. If there's a way for them to coexist where the federal law and the state law can exist together, we try and interpret it that way. But sometimes they have decided to preempt the whole field, and there's just not any room for the state to do anything different. And figuring that out is sometimes an exercise that takes quite a bit of time.
Okay, so do circuit court judges, I'm not sure, do circuit court judges have ethics codes stricter than Supreme Court? How and why? And the state of appeals?
I'm not, read that again. Do circuit court judges and state appeals have ethics codes stricter than the Supreme Court? How and why? Well, we have the Code of Judicial the canons, conduct. The Supreme Court, the U.S. Supreme Court, they don't have one. So I would say we have one, they do not have one.
Yes, we also have a board for the Commission on Judicial Fitness that polices us and makes sure that we are following those rules. We have a Government Ethics Commission that requires that we follow those rules. The Supreme Court, I think, is now taking the position that it would be a violation of separation of powers for the other branches to impose upon them a judicial code, but they're saying they're regulating themselves, but there's nothing written down.
What is the difference between district court and circuit court? Any solution to the shortage of attorneys practicing civil cases in Coos County?
Good question.
Oregon no longer has district courts. We used to have district courts back in the day, both a district court and a circuit court. District court had jurisdiction over certain types of cases, some of which would be lesser dollar amount cases, misdemeanor cases, but not felony cases and not major civil cases. Those belong in the circuit court. So we had, back in the day when I was practicing in Coquille, here in Coos County, we had 2 circuit judges in the courthouse in Coquille and 2 district court judges, one in North Bend, Judge Jones, and Judge, name escapes me here, Judge Reeves in Coquille. So 2 district court judges and 2 circuit court judges. And then in Gold Beach, we had 1 circuit court judge, Judge Starkweather, and 1 district court judge, Judge Michelson. But the legislature got away from, I should say, the state court went to a consolidated court system in which we have only one trial court level, and that is the circuit court judges. So we now, as circuit court judges, do everything that both the circuit court judges and the district court judges did in the day. All misdemeanors, violations, small claims, and then all the big cases, the major felony charges, the TPR cases, the serious cases we handle at the one level. So we truly are the trial judges, just characterized as the trial judges. There was a second part of that question that I don't think I covered. Yeah, we have a crisis in our judicial district, both in Coos and Curry counties. We have a shortage of lawyers that are doing this type of work, both criminal work and civil work. The lawyers have aged over the years and have retired or are retiring, and not a lot of young lawyers coming up. And the crisis really was more of a crisis in the criminal law aspect, because we ended up, I'm sure you've read about this in the newspaper the last couple years, the shortage of lawyers available to appoint or assign to individuals charged with crimes, indigent defendants, who are entitled to lawyers. Under the Constitution, everyone is entitled to a lawyer, and that would be a court-appointed lawyer if you don't have enough funds to hire your own. Well, we had a shortage of lawyers back in the day that were doing that type of work. We have a public defender's office here that handles some cases, but they were overworked, and they had exceeded their capacity in taking these types of cases. So we struggled for many years in getting lawyers available for indigent defendants that were in jail. And as a practical matter, what happened was that because they did not have lawyers available, the jail couldn't hold them. There was a federal judge ruling that said the jail could only hold folks for a certain number of months or time without a lawyer. And if they didn't have a lawyer, they were let out of jail. And then I would have them come back every 6 weeks to see if they had a lawyer for them over and over again. And oftentimes they didn't show up in court. But the good news is we have a group of about 5 or 6 lawyers, private lawyers, that have formed an alliance. They call themselves the Coos Defense Alliance, that are taking these types of cases for us. And so we do have a number of lawyers now, fortunately, that are helping us with these indigent defense cases. The civil cases, we're just missing lawyers. I wish I had an answer for that. We truly are trying to get lawyers to come to our judicial district. In fact, I'm real proud of an effort that the state bar has underway that I'm part of, and that is a rural assistance program encouraging students from the law schools to come down during the summer and be externs, be our externs in the courthouse, to learn about the courthouse, get out in the community, meet other lawyers in the community, try to get them excited about coming to Coos and Curry counties to practice law, because this is a great area to practice law. With people retiring, this is a wonderful area to practice law. You can live a good life, enjoy the out of doors, and contribute to being a lawyer. So the word is out. I'm hoping it's going to work well. The plan is, on this rural assistant program, to excite the externs about the benefits of Coos and Curry counties, have them go back to their law schools, and spread the word that Coos and Curry counties are an excellent place to practice law. So I've got my fingers crossed that it may work out.
Yeah, this place is a really incredible place to learn to come and practice learning how to do the law, because we have a docket that our courts have been really good about keeping to make sure that trials move through here. We don't have delays of 2 years like they have in Multnomah County to get a civil case to trial. I mean, the courts are really good about having our cases go to trial. We have a higher percentage of cases that go to trial here than in other places. Do a lot to the management of Judge Stone and Judge Barron before him to make sure that we're doing things. So it's a great place to come and learn. A lot of the higher level attorneys in some of the big cities now, or the bigger counties, started in Coos. People came here and learned how to be a trial lawyer quickly, and there's a huge opportunity here. So at all levels of the judicial department, we're trying to kind of market the rural areas to the law schools. You can come here and have a successful practice fairly quickly, and we have a lot of experienced attorneys that are willing to mentor younger attorneys. There are a lot of experiments with trying to figure out how to get young people to come here and be excited enough to stay here. What it hurts when we lose attorneys after they come for a couple of years and they decide that they've learned what they can and want to move on to someplace bigger with more opportunities for culture and dating and things like that. We like to get people to come here and buy a house, because then we can get them to stay here.
So what does Oregon Supreme Court have for judge term limits, and what do other countries have for Superior Court term limits?
We don't have term limits. We have age limits beyond which you can't practice anymore as a judge, but we don't have any term limits. If you can get reelected, the idea, I think, is that it would be detrimental to lose the experience of requiring those people to retire. We have a lot of people on the Supreme Court that have been there for 20 years.
We have, as judges, we are elected for a term of 6 years. And then we go back to the public, our voters, and for election again every 6 years. You'll find that there's oftentimes not a lot of turnover. We don't often draw opponents, which I think means that we're doing a good job. But every 6 years we go back to the public and ask them for approval to give us another 6-year term. 75 is the age that they tell judges that they can no longer work in the courtroom or in the courthouse. After 75, judges can be what's called Plan B judges. A Plan B judge is a judge that can go out after being told that you can't go into the courthouse and be a full-time judge and do Plan B work. They might send you to Multnomah County. They might send us to Jackson County or Josephine County to do work there during the Plan B service. Plan B service is about, I think it's 5 years to get some Plan B work. It's not day-to-day work. It's certain hours every year we do as Plan B work. My plan is when they kick me out of the courthouse, finally, I'm going to do some Plan B work. We actually, as state court judges right now, we can be assigned to work in any of the districts. I've had cases in Jackson County. I've had cases in Deschutes County. I've had cases in Douglas County where they've used me as a fill-in judge from time to time during the term of service. So, but 75 is the kickoff, or the date that they shut the door in the Coquille.
Okay, so what percentage of all decisions get overturned?
It's really very small. We hear from the trial judges that it's too often, but uh, usually about 75% of the cases are affirmed. Our trial judges do a really good job, and they have to be presented with the opportunity to make the right decision. So you have to argue the right thing in order to have your case overturned by the Court of Appeals. You have to have given them a chance to make the right decision. So a lot of our cases give deference to the trial court findings, give deference to credibility determinations that are made by the trial judges. And so it's set up that way that it's hard to win in the Court of Appeals.
Right, I agree with that. It's critical on the trial level, and again, Judge Jacquot mentioned it. It really is a fast-paced environment at the trial level. We oftentimes don't have a chance to think about issues and analyze issues and go back and research issues. I try to do that when I know cases are coming up. I'll spend time the week before on the weekends trying to research and anticipate issues. But oftentimes during these suppression hearings, these 3 or 4 hearings in an afternoon, it's pretty rock and roll situation. We have to move fairly quickly and think pretty quickly. But one thing we can do that makes our decisions fairly firm, hopefully firm at the Court of Appeals level, is to make good findings, to indicate what our thought process was, how we evaluated the evidence, what weight we gave certain evidence as opposed to other evidence, to make a good record that the Court of Appeals can look at and say, this trial judge really thought it through and made good findings, and we're not going to disturb what the judge said at the lower level. Also, if we make credibility findings, Judge Jacquot mentioned that, if we say we found that witness A was credible, we found witness B was not credible, and because of that, we thought the evidence weighed this way. By making that credibility finding, or those findings, it makes it easier to survive an appeal if it goes up to Judge Jacquot's level.
Well, and it's better for us to be able to defer to the trial court judge who actually gets to see the witness and see whether they're trying to dodge the questions or whether they're answering it in a way that they actually knew what they were talking about, or whether they look like they're trying to make it up at the time. There are lots of good reasons to defer to the trial court's and assessment of witnesses.
One thing that folks ask me from time to time is, what about jury verdicts? Does the Court of Appeals challenge or reverse the jury verdict? The answer is no, because that's not the role of the Court of Appeals to second guess what the jury has done. What the Court of Appeals is looking at are more the legal issues. Was there an error made during jury selection, for example? Was there an error made by the lawyers in their arguments to the jury? Was there some error made in terms of evidence that I've received during the courtroom? A lawyer makes an objection during a trial. I rule that objection's sustained. I'm not going to allow that evidence in, or overrule the objection, allow the evidence in. Those types of legal rulings are reviewed at the appellate level, but not what the jury's done. If the jury says we find the person guilty based upon the evidence, that's what it is. And they're not second guessing what the jury has done.
So this question kind of follows that a little. What kinds of cases can have a jury trial, and what's the advantage of having a jury trial?
Go ahead.
Jury trial, the Constitution guarantees jury trials. Cases involving civil cases or cases involving private parties, somebody suing for money damages. Those types of cases obviously can go to a jury trial. All criminal cases are people accused with crimes are entitled under the Constitution to a jury trial. In fact, the Constitution also says civil trials. You're entitled to a jury trial if the amount's more than $20, as I recall, at the federal level. So those types of cases, you're entitled to a jury trial. It's not unusual, strike that. From time to time, an individual may waive a jury trial and have a judge decide the case. Individuals have that right. If you're accused of a crime, you might decide that we don't want to have a jury trial. It raises some legal issues. We'd rather have a judge handle the trial. I had a case a couple weeks ago where the individual was charged with a crime and decided to waive a jury and have the judge try the case. I sit then like a jury does. I listen to the evidence and decide whether or not the state has proven beyond a reasonable doubt the defendant's guilt. But again, as a general rule, all those types of cases result in jury trials. Some matters don't get jury trials. I mean, workers' comp cases where people are hurt at work, those are not handled by way of jury trial. Used to be in the day it was, but that's changed now. It's done at the workers' compensation level. Other types of cases that we have do not have jury trials. People charged with what's called violations. Certain types of violations they can, but as a general rule, not all violations are jury trials. Traffic court matters are not entitled to jury trials. Eviction matters are not entitled to jury trials. But it's primarily the civil cases, money damage claims, property disputes, those types of things are jury trials, and all criminal cases are jury trials.
That's one of those interesting areas where we haven't incorporated the federal constitutional right to a civil jury trial, and you only have in Oregon a state constitutional right to the civil jury trial. So again, it doesn't make a practical difference. You still have the right, but the source of it is not the federal constitution. They have not incorporated that federal right onto the states. We have a strange process where the Supreme Court has to decide to incorporate one of the Bill of Rights amendments onto the states through the 14th Amendment, or else it doesn't apply to the states. And the jury trial right is one of them. Also, the right to a grand jury is only a state right.
What does Oregon law require for a police officer to ask you to identify yourself? Do you need to show an ID or just tell them your name?
If you're driving, you have to show them ID, but otherwise, you don't have to tell them your name either. They have to have reasonable suspicion or probable cause in order to stop you in certain.
I agree.
So this is for Judge Stone. Have you ever
I ever done something bad? Yes.
have you ever thought the jury made the wrong decision, and what can you do if they make?
Yeah.
You know, I think I've had that question asked before, and over the years, I don't think I've ever really questioned what a jury has done, and I've handled many trials. I once in a while in a civil case, when the jury awards a lot of money, I might have wondered about whether or not the evidence supported that. But I never, ever questioned a jury verdict. I appreciate the folks coming in my courtroom. These are our citizens here that are doing their duty, and I've always thought that what they've done is right. And I can't think of any time in my career that I've ever thought, "Well, that just didn't make any sense." I just respect the jury process that much, and I tell you, people ask me what I like the best about my job, my role as a judge. I love dealing with jurors. I have so much appreciation for our jurors and what they do and what they sacrifice to come into my courtroom, our courtrooms, giving up their time, listening in the jury box to the evidence, making a decision. And I appreciate their service so much, and I let them know that. And over the years, I've gotten the greatest letters from jurors saying, "Thank you, Judge. This was the best experience we've had during our lifetime. We want to come back one of these days." It just makes me feel like we're doing our job right. So to answer the question, no, I never second guess the jury's decision.
I came out of my 7 years as a trial judge with as a great believer in the jury system. I think they usually get it right. There are times when they'll do a compromise verdict, where they'll find not guilty on one thing and guilty on another thing. Because I feel like they do a really good job of finding facts and being fair.
This is for you, Judge Jacquot. You mentioned something about Oregon Constitution being interpreted independently of the U.S. Constitution and said that was unusual. Can you explore the ramifications of that a little more? And in how many states is that the case?
So I believe there are 4 that do the independent constitutional interpretation like we do, including Hawaii is one of them. Washington does some of it. Most states do what's called lockstepping, and if the federal courts have it interpreted a right, they just interpret their analogous state constitutional right exactly the same. So, I mean, I think that it has real ramifications with regard to being able to adapt to modern circumstances. The only way that the federal Supreme Court has been lately applying the Constitution to modern circumstances is things like search warrants with regard to electronics and things that the founders would have never envisioned, like everybody having a cell phone and things like that, and the warrant requirement. They've adapted to modern things. At least some in the recent last couple of years, they've been doing some of that, but otherwise, they basically the facts are set at the status quo at the time of 1789 when the Bill of Rights was adopted, and that really has its limitations when you look at the world that we live in now. So it's unusual, but I think that it's a better approach.
How many assistants help you when you are hearing a case, and what level of training do they have? Paralegals or junior lawyers?
I can start at the trial level, at least in my judicial district. We have no law clerks that work for us. As judges here, we do our own work. We rely upon the lawyers, obviously, to provide memos and make sure that they've identified the appropriate law that we could look at, precedent. But in the courtroom, I don't have any clerks that work for me. I do have a judicial assistant, Denise Thurman, who has been with me for many, many years. She handles the paperwork and scheduling, works in the courtroom, entering information as I make rulings. We also have in the courtroom a recorder, someone that works with the recording device that's taking down everything that's being said or done in the courtroom. But beyond that, I do my own research. I again rely upon the lawyers to help me out identifying certain things. But other than that, I run solo. I can tell you we've got a good the judges that work with me, and I'm the presiding judge. With my 5 other judges here, we are very collegial. We don't tell each other how to rule on cases, but we share questions among ourselves in terms of the law and how we've handled various cases over the years. So having the 5 other judges in my judicial district that I can bounce ideas with, that helps me out a lot. But other than that, I'm doing my own research and my own writing of opinions. Probably at the Court of Appeals, a bit different.
It is very different. One of the things that I told you we do is try and compare our opinions with all of the things that we've said before to make sure that we're being consistent. So we have staff attorneys that work at the Court of Appeals that do a lot of reading of all the opinions and editing, making sure that we're being consistent with each other because we have 4 panels that are making decisions. So we try and make sure that we're issuing things that are consistent with each other, also consistent with the Supreme Court. And then we have to write our opinions out, write out our reasoning. So I have 2 law clerks that work with me. They are generally lawyers. They've just graduated from law school, but they're the smartest kids from their law school classes generally, and they've worked on law review, know how to help us with drafting things. So we'll talk about a case and they'll also do some of the research. A lot of times I'll have externs who are actual law students come and work in my chambers for a few months to get credit for school. With them, I do things with them like send them to the archives to look up the legislative history for some old laws, because that requires a lot of walking. In Salem, they have to go down a couple of blocks and try and figure out what the legislature said when they were enacting the law in the first place. That's important for us to consider when we're trying to figure out what they meant when they came up with the law. So we have lots of people to help. We also read all of each other's opinions before they publish and have the opportunity to have all 13 of us vote on a case if we think that it's important enough to slow it down. That process takes about a year to get everybody on the same page and vote on those. So we try not to do it too much because justice delayed is justice denied. We're working hard on getting our opinions out quick, but there is a lot of help, and we need more help to do the function that we do.
Okay, so the public is encouraged and required to help with public services such as jury duty. Oregon is in an earthquake and tsunami territory, yet some buildings may not be safe for public or staff for these events. What are judges doing to help bring awareness and advocacy for support of safe buildings for services?
I know the judicial department is working really hard to get our buildings retrofitted so we're able to have safe places for people to come. We really wouldn't be able to do the job that we do without our jurors, and we do require them to come. There are still some courthouses in Eastern Oregon that don't have a way for a person in a wheelchair to serve on the jury. So we're working on trying to get everything up to speed, but it's a little bit tricky because the counties own the courthouses and the state judicial department basically requires them to have them, facilities that are adequate to meet our needs. And it takes time sometimes to come up with the funding to be able to do those things.
I agree with that. It's been a major concern to me over the years. The courthouses both in Coquille and Gold Beach need to be replaced. They're older buildings. There's some issues in terms of the physical structure itself on both locations. The legislature, OJD has been, the Oregon Judicial Department has been a good advocate in trying to get new buildings, new courthouses around the state, but it's a slow process. I think we've been on the list for many years in terms of needing a new courthouse. They've got new courthouses in Clackamas County and I think up in the corridor, but so far not either in Coos or Curry counties. The one thing that we are doing that we have some control over, a bit of control, we're trying to increase security at both the courthouses in Coquille and Gold Beach. I've been concerned about that over the years because we don't have any front door security at either of the two courthouses. And we ask our jurors to come in and do their jury service. We ask lawyers to come in. We ask parties to come in. But there's no metal detectors at the front door. Folks bring guns into the courthouse. They bring knives into the courthouse. And we can't stop that without metal detectors at the front door. We had hoped this last legislative session that the legislature would give us some funds to actually place some screeners, some live bodies to stand at the doors in both locations to screen people as they came in. We have the machinery, we have the X-ray machinery, we have the devices that are used to detect weapons and knives, things like that, but we don't have bodies to operate the machines. And the courthouse or the commissioners, the county doesn't have a lot of money that they can pay to folks to stand there at the door to be screeners. We were hoping last legislative session that they would give us some money to hire screeners, but that did not pass. That did not come through. We're going to try again, and not during this short session that just ended, but this next long session we'll try again. We've got the materials there. We need to get some funding to hire screeners at the front door. We do have deputies available at the courthouse in Coquille and in Gold Beach that provide security during courthouse proceedings, but they're not there every moment of every day. When I identify major cases that I think pose some security issues, I'll have them come over and stand there to provide some security. But otherwise, we're just keeping our fingers crossed. But I can assure you, we're doing everything that we can to keep our folks safe. The building itself is a different. I can't control that. It may collapse one of these days, but hopefully we'll be toward the top of the list and getting a new courthouse one of these days.
There's a panic button. It takes about 45 seconds for them to get from the jail over to one of our courthouses. I know because I accidentally hit it once.
Could you please speak to the difference between a writ of review and a declaratory judgment?
Well, a declaratory judgment is available at the trial court level to try and get the court to say, these are the rights of the parties. You have the right to have this happen or the right not to. A writ of review is a procedure that the Supreme Court uses to order other arms of the state to do things or not do things.
And we could have a writ of review at the trial court level also. If a county department has made a decision and the individual did not like that decision at that level, they could petition the court for a writ of review to ask the trial court judge to take a look at what the county had done at that level and make a decision whether or not there was an issue with that. So it doesn't happen very often. I think I maybe have had 2 or 3 over the years, but that is available both at my level and also at the appellate level. Easy question.
This one may be easy. Can volunteers not be screeners for courts to use the machinery for security purposes?
I wish the answer was yes, but I think there's some liability issues in terms of liability issues. I think the sheriff would be concerned about that if somebody came through and didn't got through the screener, and there was a question about whether the screener did something wrong and letting him through. It creates liability issues. So, and it could be dangerous too for the volunteers. Hopefully, what they'll get for us are folks that are experienced, that are law enforcement related magistrates from that can run these machines, or deputies, if they can fund some of the deputies to come over and do that during the day. But volunteers, I wish the answer was yes, but it's not going to happen.
The League of Women Voters asks judicial candidates questions in interviews and on our Vote 411 website. What are some questions you think we ought to ask?
I always like when they ask what your judicial philosophy is, because that gives you a little bit of a chance to talk about your feelings about justice and access to justice. Those sorts of things don't tend to lead to you giving advisory opinions on subject matter. So I think questions like that, as well as a lot of questions about experience, questions about what you think are the most important issues that courts are dealing with, and the breadth of experience with regard to the numerous things that judicial candidates have to do. Judges have to, we have general jurisdiction judges in Oregon, so you don't generally do as well if you're a specialist in just one thing. When you come into that job, you're going to have, eviction matters in the morning, the probate matters in the afternoon, criminal stuff. If you've never done that, that's hard. So just figuring out how qualified the person is.
I agree with that. I think experience is important. I think questions about the individual's experience and what experience they've had in certain areas, I think that's something the voters need to know. And I would be happy to answer those questions, or those types of questions. But in judicial philosophy, I suppose, long range. But other than that, what Judge Jacquot said is what I think.
I also think it's important to ask about soft skills, about how much you care about serving the public, and are you open to making sure that people have a good experience when they come to the court? Because after all, we're an expensive form of customer service, but that is what we do, is try and provide a service to the people.
I think that's all of our questions. Thank you all for coming, and thanks for all the great questions. Yeah, and thank you, Judge Stone and Judge Jacquot.
Thank you.